We're joined by Senator Lee.
Thanks so much, Mr. Chairman. Mr. Levine, I'd like to talk about 13B. You wrote in your testimony that in the context of 13B, quote, restoring the FTC's ability to provide redress to wronged consumers is critical, close quote. But of course, in the AMG case in which that ruling was issued, the court specifically noted that its decision did not prohibit the FTC from using its authority under Section 5 and under Section 19 to obtain redress for wronged consumers. Is the Supreme Court wrong? Under other existing authorities, are you unable to provide any redress for wronged consumers?
It's possible, Senator, but it's very difficult, and I'm happy to talk through why if that would be helpful.
Okay, well, I mean, it is pretty significant. I mean, there was a significant ruling. The ruling was significant on its face. It also happened to be unanimous. And what the unanimous court found in that case was that over 40 years, over a period of over 40 years, the FTC had been illegally obtaining money from companies. And we're not talking about some trivial sum. We're talking about billions of dollars. Now, I certainly want to ensure, as I know you do, that consumers who have been harmed can be made whole again. But I think we can't ignore what's happened. And I think it would be legislative malpractice on my part if I were to decide to jump on board with something that would grant the Commission the very same authority that the Commission used for 40 years, not only against bad actors, but also against lawful actors, against legal, non-predatory business practices that were providing legitimate goods and services. And so I think instead of just giving carte blanche authority, Congress should ensure that this authority is coupled with proper safeguards in order to block any future abuses of this immense power. Now, let me make sure I understand. Are you against any guardrails around 13B-like authority for the FTC?
I think the best guardrail for our 13B authority is the fact that the FTC can't order anybody to pay a nickel. We need a federal judge to order any payment. We needed that under 13B, and we need it under some of the legislation the Senate has considered.
Okay, so in injunctive relief, you're saying that they need to be able to have injunctive relief, but they have injunctive relief. What other types of reforms would you be willing to support? What kinds of guardrails around the authority to do what the unanimous Supreme Court said they were unlawfully doing for 40 years in the AMG case?
The biggest reform we need is the ability to return money to consumers, Senator, who have been scammed. You're right. There are other ways to do it. It'll take 5, 6 years. It could take years. And by the time we actually get money back, by the time we actually get a judgment and we're through the appeals process, the defendant doesn't have any money anymore. The best way to stop fraud and get money back to consumers is restoring the authority we had.
Look, ensuring that consumers can be protected from scams and from unfair and deceptive business practices is extremely important. And we need to get this right when we do it. It is also important, not in spite of the fact that the aforementioned is important, but because it's important. It's also essential that we ensure that consumers continue to have access to goods and services provided by legitimate businesses. These two goals don't have to be at odds with one another. In fact, due process allows for them to be pursued effectively and simultaneously. In fact, that's what due process is. It's why we have it. It's why it's built into the Constitution, not just once, but twice. I believe Congress can grant the expansion of 13B authority while also providing appropriate safeguards, safeguards of the sort outlined in my proposed legislation, S 3410, which is called the Consumer Protection and Due Process Act. And it would protect consumers by, one, providing the FTC with the ability to pursue monetary equitable remedies as against bad actors, and two, providing businesses due process protections from improper, unfounded, and frivolous claims. Which leads to a concern that I've had. You know, under the COVID-19 Consumer Protection Act, the CCPA, it's illegal to engage in deceptive marketing related to the treatment, the cure, the prevention, the mitigation, or the diagnosis of COVID-19. Over the past years, the past 2 years, roughly, since that's been in place, many hardworking Americans have stepped up to the plate and have worked diligently to identify or create or develop inexpensive therapies and treatments against COVID-19. Lamentably, it seems that the federal government is keen on promoting only some solutions, while essentially blocking medical professionals from delivering other FDA-approved medications for the treatment of COVID, treatment options that are often far less expensive and far more available than the government-pushed approaches. And I find it quite concerning that this combination of the FTC, the FDA, and other entities seem to be trying to block the off-label use of approved drugs when it comes to tackling the COVID-19 pandemic. In some cases, it's off-label use of previously approved medication. In other cases, it's anything that looks like it might help relieve the symptoms of COVID or otherwise address COVID. And so, look, it's not illegal for healthcare providers, in their best judgment as medical professionals and with the health history and the best interests of their patients in mind, just prescribe off-label uses for approved drugs. You think this is a valid and important practice that's being hampered by the FTC and the FDA?
I think it depends on the circumstance, Senator. I can say that we certainly don't regulate the practice of medicine, and I think if you look at the cease and desist demands we've sent, the cases we've brought, you know, frankly, Senator, these are not close calls. These are hucksters, these are fraudsters who are selling people snake oil. So I think some of the concerns you raise, I'm happy to...
So you're saying that you go only after those who are selling snake oil or the modern day equivalent. Mr. Chairman, I see my time's expired. I've got just one or two follow-up questions. I'll be fast. Thank you, Mr. Chairman.
We go after a wide range of COVID-related frauds.
You do.
And they're not close calls.
In your testimony, you mentioned that the first case that you filed under the CCPA was against a chiropractor due to claims about the use of vitamin D and zinc supplements to treat or prevent COVID-19. And in the complaint filed by the Commission for that very case, you noted that you would seek to bar health claims unless, quote, unless, and the following is a quote, true and can be substantiated by competent and reliable scientific evidence, close quote. How do you determine what meets that evidentiary standard, and by what process does the Commission make these determinations? What process does it follow to protect the rights of those who don't think they're selling snake oil?
The short answer, Senator, is that we have to persuade a federal judge. It's been the position of the FTC for decades that if you're going to make a health claim, there needs to be a reasonable basis for it, or else it's deceptive. But we can't just announce that.
And what guidance do you provide them about what's deceptive?
We've provided extensive guidance both through our casework and through our business guidance on ftc.gov around the types of bases we look for making medical claims. But again, if we're going into federal court alleging that a claim is unsubstantiated, we're only going to win if we can convince a federal judge.
Yeah, and therein lies the tie to what I'm describing about the need for due process. You have overwhelming power at your disposal. You have presumptions in the eyes of an entity that is staring down the barrel of your enforcement. It's not an even playing field when they walk into that court. The immense authority that you've got at your disposal within your discretion is itself looming, and it can and does shut businesses down entirely. Now, I understand that difficult line drawing problems inhere in the practice of government, but let's not pretend This happens in a vacuum. And let's not pretend that this doesn't connect back to the need to protect due process and the need for there to be guardrails around 13B authority. So in light of that, I hope, expect, in fact, I demand that you reconsider any opposition you might otherwise have to having guardrails around 13B authority. We can protect consumers, and we must, but we've also got to provide American businesses, American consumers with due process protection. Thank you, Mr. Chairman.